This is a partner report in the national Optis Cellular Technology LLC, Apple Retail UK Ltd.
Mr. Smith.
My lords, I've got a few housekeeping matters to get through before I resume on the US proceedings. The first of which is, my lords may recall that we promised to hand up a chronology as to how things were dealt with answering the judge's questions, who was in the box when and all that.
Yeah.
We prepared that and sent it to the other side a day ago, something like that. And if I could just hand that up.
I'm sorry.
It's just a single sheet. I don't actually intend to say anything about it. I hope it's self-explanatory. Thanks. The second housekeeping matter is to deal with a point that I promised my Lord Justice Newey, chapter and verse on where we saw in the materials both parties in their apple pie method not normalising to 1%, but in effect giving stack shares the weight of their stack. Could I just show my Lords a couple of documents on that? The first is Apple's opening skeleton, so you need supplementary 1, tab 2, pages 14 and 15 of the bundle. And it's actually paragraph 12 at the bottom that bridges the page. This is where they're setting out what I've called the apple pie approach. And for instance, if you go over the page, what they've done quite clearly is just add up everything in their collection of comparable licenses. You see, for instance, 5 lines down on the left-hand side, a collective cost of. That's all they've done is add it up and then add up what the stack share is. Our response to that, but don't put sub 1 away, but can I ask you to take sub 2 out as well? Our response to that was a piece of paper we put in responding to that paragraph, is in sub 2 tab 54. So it's page 352. It was from the numbering, it was in X1 in the trial bundles. And what in substance is going on here, the first half of it is we're saying they've made an error in their own calculation. And then the bottom half is us saying, this is what you get if you put Google in. Sorry, not Google, Qualcomm in. And so we're doing the same thing, but including an extra license, so the stack share is higher, but so is the collective cost. So that was us responding to their way of doing it by both correcting their arithmetic, but also showing what we do if you put the other license in. We dealt with it also in our closing.
Slow down, sorry. Tab 54.
Yeah, sorry.
Which?
Tab 54 in supplementary bundle 1, page 3. 2. 352. It's one page, and it has at the heading paragraph 12 of Apple's opening skeleton. Does my Lord not have it?
I've got it now. Thank you.
And just to repeat what I said before, the first half of that is correcting their maths on their approach, not including Qualcomm.
Yeah.
And the bottom half is saying Qualcomm should be in, and this is the number you get if you do that.
Nice. Thank you.
Our closing, so I'm back in supplementary bundle 1 at tab 3, also deals with this. It's page 50. And it's for instance, 296, actually all the way through to 301, where we deal with putting this to Miss Guttridge.
Would you like us to read those?
Not now, my lords. I'm just giving you all the references. In fact, I'm going to give you one more and then say actually they're all summarised in paragraph 45A of our skeleton.
I see, okay.
Because I promised my lord that
Yes.
I would show you what they are.
Yes.
I felt that I needed to. The last one is SUP 2 again, which is another part of our closing, where we refer to the underlying data and how the aggregates were calculated using both linography and PA. That's SUP 2, tab 56. Page 356. That's just us setting it all out. And as I've already foreshadowed, those references are summarised at 45A of our skeleton on this appeal. And I've taken you to them because I promised my Lord Justice Newey that I'd show where it was that both parties were proceeding on the basis that the way you do this kind of exercise is not to normalise to 1%, but you just add it all up and therefore give each component a weighting that's equivalent to the size of the stack.
Why isn't that the same thing as normalising?
Why is it? Because you're not reducing or making each one as if they're 1% and then taking an average of that. You're adding each one in. So if you've got
So
one,
you're not taking an average. I get that you're not taking an average, but aren't you doing the same thing when you, as you put it, normalise to the stack share? Isn't that the same?
no, you're what you do is you add it all up and say it comes to 50% of the stack share. You then are normalising at that point in the sense you're extrapolating to what it would be at 100%. But what you're not doing is combining them all as if they were all equally 1% weight.
I see. You're adding up all the DPUs.
Yeah.
Just so that's the total number of dollars. And then
Yeah.
you're also adding up all the stack shares. That's the
So
total
if you go back
so
to
for the sake of argument, if the total of the stack shares is 50%, then when you've added up all the DPUs, you double it and say that's what.
Exactly. In the example I gave to my lords in argument, £42, you double it rather than normalising them all to 1%.
It's a weighting effect.
Yes, it is. Yeah. So that's the second housekeeping matter. The third and the fourth are in fact answering two questions that my Lord Justice Birss put to me. And one was directly on rounding, and one was a question about why you get that difference between taking Google out and not. And actually the answer is rounding, so they both relate to rounding. And let me deal with the first one first. My lord asked about the boxes, the orange, yellow and green boxes that are part of the appendices and how they were calculated with
Where
rounding.
are these? Remind me where these are.
They were in supplementary 4, tab 26 and 28, I think.
Yeah.
And actually we can just do it from the ones that are in tab 26. And there is a potential difference between the two approaches. And let me explain what they are. This is, you will recall, if we're looking at tab 26, a printout of individual DPUs, which have then been scaled to the Optis portfolio, and then the average at the bottom has been used to calculate lump sums. And the query that was raised by the other side which we actually have dealt with in a response, which I'll show my lords in just a minute, is where was the rounding done, if at all? And there are two possible approaches to this. And one is you take the scaled DPUs that are rounded and then average, and then of course you have to round then, or you take the scaled DPUs which are not rounded and round only after the average. And what has happened in ours is that the scaled DPUs have been taken and rounded, then averaged, and a rounded DPU is taken from that and totted up for the lump sums. Whereas I think what the other side is saying is that it would be more accurate to take the scaled DPUs that are not rounded, average them, and then take the rounded average. So you only round at one point in the process. Now we can see the force of that, and so I don't think it affects very many of the numbers. And as I think I said to my lords yesterday, we think actually overall it helps us, but we're quite happy to do just the rounding at the last stage. So what we will do is reprint the annexes or appendices with the rounding only being applied at the average, so that the scaled DPUs are not averaged. But there was that difference between the approaches as to where you rounded. And just for my lord's note, we'd had answered that. I don't think you need to turn it up because I've explained it. It's supplementary 5, tab 40. But what we'll do is, as I've just said, and we'll make sure that those are provided to both my lords and the other side. Now, the last point doesn't actually relate to a difference that arises because of that, but is also to do with rounding. It was a question that my lord asked me about why the DPUs, I think the free release DPUs, between Mr. Besant and Miss Guttridge in the lump sums looked very similar with Google in, but when you took Google out, it made a difference of something of the order $30 million. Mm-hmm. And that is to do with just rounding, because the units are so enormous. And let me explain that. If you have a difference between the two of them on the DPU that's say 0.4, so you round it so that in fact it's no, on the price of the DPU it's the same, you can then take Google out and then do the averaging, and it's now 0.6. And so that rounded DPU that you're taking, the difference may be a penny. And that's all you've got to have, because when you then, the units that Apple are selling are so enormous, a change of 1 penny can make, 1 penny in the price can make that level of difference in the lump sum. I'm worried my lord's still looking puzzled.
I am.
Right, let me try again then. Let me try again then, because
because the two numbers came out the same in the two. Because the point is, it's a place in which the Guttridge and the Besant numbers come out more or less the same.
Yeah.
And then adding one more license now means they're different.
Yeah, because let me try again. Let's assume that they're not quite the same.
Sure, well, I no doubt that they're not quite the same.
But the underlying numbers are not quite the same, but because you round at the stage of where you take the DPU, say they're 0.4 different, but you round so that they are the same, or they both get rounded to the same DPU, to the nearest penny.
What DPU you're talking about, Mr. Speck?
The DP that is at the bottom of the columns that you then take to multiply, but you then take to multiply up by the units.
So the thing called weighted average?
Yes.
Right.
So if they are the same, they're not, the underlying numbers are not exactly the same, but they round to the same. That's the number you're taking to multiply by the 3 billion units.
Right.
If you then take one out so the average is slightly different each one, so that they then round to a different number, so that you get a penny difference in the rounded DPU that you take,
Right.
you can get a big difference of 30 million in the total lump sum paid, and it's just a consequence that the unit price you take has changed by a penny, or the difference between them has changed by a penny.
But the change in the penny is partly accounted for by the rounding.
Yes, exactly. Actually, the change could be very little. They could be quite close to where the rounding would have gone the other way.
Yeah.
But the rounding has tipped it over, and so it's a consequence, my lord, of ultimately we're obviously inviting you to look at a DPU, and I don't think anyone's suggesting you go to a DPU that's more accurate than 2 decimal places, so the nearest penny. But in terms of what's actually paid by somebody that's making the level of sales that Apple do, that can ultimately make a significant difference of the kind that appears. I can see that I'm still struggling to get.
Yeah. It's all right. I mean, no doubt you're right, Mr. Speck. It's fine. I'm not.
It is.
It's not that I don't believe you. It's just that I don't.
Well, you
believe
don't understand. so that's halfway to not believing.
Exactly. You haven't convinced me you're right.
Well, I'm told that that's what's causing it, and I certainly understand how that can cause it.
I think the answer, if you don't mind, I would like to get to the bottom of this.
Yes.
We're going to take time of it now. I think the answer is to provide numbers which are not rounded and show me where the difference comes.
Okay, we'll do that.
And I think that's what should happen.
And it may even be possible that we can do that in an agreed way, because I would hope the other side would agree that can happen.
Whatever. I mean, that's fine.
Yeah. So I think that's all the housekeeping that I wanted to do.
I mean, I tell you, Mr. Speck, what that makes me is very suspicious about the utility of the data as it appears in the material you've given me. It doesn't mean it's wrong, but it means it's misleading.
Well,
I feel misled
yeah, well, I understand.
by
That's
numbers in the pages, because if it is all about rounding, it shows you why the approach to rounding was really not helpful at all.
Well, let me. I think both sides are rounded at the average side. I don't think it's anything to do with me saying that we'll take the individual scale things unrounded. It's all to do with rounding when you get to the average, as I understand that point.
Okay.
And just to be absolutely clear.
But if it sounds like you've rounded when you've reported an average, but then you haven't used the rounded average. You've used the actual number.
No.
Okay.
No.
Okay.
Both sides agree that you round at the average point in time, and you round to 2 decimal places.
What I've understood, I'll say this once, and then we'll stop and we can move on. What I understood your explanation to mean is that as I'm looking at the page with the information and picking a number at random, it doesn't matter, but the bottom right hand, very bottom, weighted average, dark blue, whatever, that number that's there as stated as a rounded number to 2 significant figures, which is identical to the number for Gutteridge and Besant, the calculation which produced the millions number didn't use the number that's stated on the page, it used a more accurate version where the 2 numbers differ from each other.
No, that's definitely not it.
You're telling me that's not right, in which case I don't understand what the point of that number is, because if it's not being used for anything, what's it for?
No, the number at the bottom, rounded, was used to calculate the lump sum.
Right.
It's just that when you take Google out, the rounding causes that to be different by a penny between the 2.
I suggest that just put on a piece of paper, because we've got some rather fundamental issues of principle to address when it comes to the US proceedings.
Yeah.
And you're running out of time.
Yeah, I will do. I'm sorry,
That's all right.
Longer than I thought. Can I move to the US proceedings? We've set out the factual background at paragraph 181 of our skeleton, and I'm going to start with the section actually that begins at 196, how we came to have 2 sets of proceedings. And as I've already alluded to, the trial F aspect of those proceedings was basically about the position that Apple adopts, where they basically want to say that they're entitled to litigate while avoiding injunctive relief, but saying that they can decide not to the licence at the end. And so Optis was faced with the prospect of litigating for very many years, and then down the line Apple withdrawing from the UK to avoid taking for and paying.
Sorry, Mr. Speck, I appreciate you're under time pressure, and I value what's been put in writing. It's entirely my fault, I'm sure, but we have so much material in this case that I've struggled in this regard to get my head around the simplest basic point, which I think is rather fundamental to Apple's case, and therefore we need to be crystal clear about, which is where the position was as at the date these proceedings started.
In America,
in the US and here. So take that as the point in time. What was going on when the claim form was issued?
Going to come to that.
So we need to know what the state of play in the US was at that point in time and what was in the claim form.
Right. They have a position that they take, that they are not going to take the licence and that they can make you litigate country by country. We knew that. The claim form and the American proceedings were started on the same day. They pursued that policy in these proceedings, the one that I just referred to, right the way up until the 15th of September 2023, after they knew the first instance outcome in the US and here. They committed to this court.
I'm sorry, that's not a full answer to my question.
Oh, sorry.
You've clarified the date, which is as I thought, but one then needs to know what the scope of the respective claims were.
I'm going to show you what their position was here, and I'm going to tell you what...
I need to know what your position was. That's the starting point, because you were the claimants in both jurisdictions.
I'm going to tell you that as well.
Thank you. All right.
We were faced with that policy that they said that they were taking. So as a consequence of that, which is an entirely reasonable thing to do, we started proceedings both here and there. And as I've just said, they were started on the same day in Texas in February 2019. We have always explained our preference for a single determination in the United Kingdom, but because of the stance taken by Apple, we could not guarantee that.
So where do we see that?
Where do you see that?
You told them at the outset you wanted a single determination.
We've said it in several witness statements and they rely upon it. I think it's common ground. I'll find my Lord a reference.
Thank you.
They particularly rely upon it actually, so I don't think that will be an issue at all. In the US, we asserted infringement of several US standard essential patents, and we sought declaratory relief as to the FRAN nature of Optis's conduct in negotiations with Apple. We set that out in paragraph 182 of the skeleton, where we also point out that in the end only 5 US patents were tried, and we give you the reference. As regards the claim concerning patent infringement, Apple voluntarily submitted to the jurisdiction of the Texas court and participated fully, as we point out in paragraph 183. Indeed, the existence of parallel proceedings was consistent with his stance that there should not be a global determination at all, despite the decision in Unwired Planet. That was in fact another point it was reserving to have another crack at in the Supreme Court. For my Lord's note, as we explained in paragraph 184, there were 2 jury trials in Texas in 2020 and 2021 respectively. The second was a limited retrial, and the end result was a judgment in Optis's favour for $300 million as a lump sum for past and future sales of 4G enabled phones, iPads and watches. And we set out a key passage from the order embodying the judgment of para 186 of our skeleton. It's the order of Judge Gilstrap, well-known US District Court judge in this field. And the document itself is a supplemental 2, tab 2, sorry, yes, page 17, sorry, so tab 3. It's a wrong reference. Sorry, let me just find that. Where it is.
I think that must be the reference. Yes. That must be the reference.
Oh, it's one in the core supplemental bundles. Core supplemental bundle, tab 38. And the text that I'm referring to is 5 lines from the bottom, picking up and stating what the jury returned as a unanimous verdict. And if you turn over the page, paragraph 2 on page 258, you see the award is for past and future sales. So, my lords, the upshot is that very substantial sums have been spent on US litigation, and there is a res judicata judgment where the claims are extinguished and whereby the US court has determined the value of part of the royalty payable attributable to 5 patents.
Well, you say the claims are extinguished. I'm assuming you're referring there to the doctrine of merger. Do we know the doctrine of merger is part of US law?
Yes,
Is that common ground?
I believe so, but again, it's in our evidence, and I don't think there's any challenge on that.
Thank you.
Lord, I'm not sure it is. I mean, it's not something on which I think there's any expert evidence. I mean, I'll have to look back at Sheasby, and I mean, it wasn't common ground before the judge.
Right. Okay. Well, that may have to be explored.
Can I pause and draw attention to this? There isn't a dispute that this, i.e. the US judgment, covers the value of the part of the reasonable royalty payable to Optis that's attributable to the 5 US patents. And I say that because the premise of the heart of Apple's argument should be that there should be no double counting. We agree with that, and that's always our position. The fight is over how the US judgment should be taken account of. Before I go further, can I just complete some key factual points? We've given an undertaking to the UK court to offer a licence settled in these courts, but Apple has also given a binding undertaking to the Texas court to pay what's due under the US judgment. And we set that out in paragraph 189 of our skeleton. But they have appealed, so the upshot is Optis' right to enforce is suspended, although the status of the judgment is not affected. To summarise the contentions on appeal, Apple say that it should be reduced to 0, and because they've appealed, Optis has cross-appealed, seeking reinstatement of the first higher award from the first jury trial. That appeal and cross-appeal would have been determined by now, probably in early 2024, if the parties hadn't had to take the steps to secure time for the judge to write his consequentials judgment. In fact, what happened is, in light of the considerable pressure from the judge at the first consequentials hearing as to the relief he might grant, we agreed to ask for a 90-day extension to the deadline for filing our reply brief, which the US court dealt with by actually staying the proceedings for that period. In fact, it turned out to be a very much longer period than we and the judge anticipated. Went from July 2023 to February 2024, as we explain in paragraph 190 of our skeleton. So there ended up being a stay for very much longer. We had to write for another extension, which was again dealt with by a stay. Just so that you know this, no doubt because of how much time had passed, in March 2024, the stay was lifted by the US court of its own motion. Apple attempted to have it imposed again but failed. So the US court wants to proceed with the appeal hearing, and as I understand things, it's just a question of us being notified it's in the list for hearing. But when the stay was lifted, Optis was in an invidious position as to steps it was necessary to take. We had to make an application to the judge to even be allowed to take the steps of filing the brief because of paragraph 6.2 of his order that I'm going to come to. Even now, my clients are not allowed to participate in the appeal hearing without making a further application to the judge, or if he's not available, Mr. Justice Mead, as we point out in paragraph 196 of the skeleton. Before I go much further, I need to address some of the more detailed procedural background to address the procedural points that my friend take. So that's a kind of overview that I've given you. Can I start by identifying a bit more of the detail? The judgment after the second US trial was September 2021. That's the one that I've just shown you. That US development was about or shortly before Mr. Justice Mead's decision in Trial F at the end of September 2021. So at that point, there was the US res judicata judgment for $300 million, and the UK court had told Apple it had to commit to the UK determined licence or face being enjoined. My lords know that Apple didn't accept that at that point in time and gave a qualified commitment, basically saying it committed only if it had to, and pursued an appeal to establish that it didn't have to commit. This court told it was wrong about that, but then it was pursuing a further appeal even after that. But that was the position back in October 2021. We'd had Mr. Justice Mead's judgment around about the time of the second US trial. The next thing I need to show you is Apple's pleaded position in this case. As my lords know, there were initial Fran pleadings in 2020 and then position statements filed with the evidence in early 2022. Can I start with the Fran defence? So that's how Apple set out its stall in 2020. That is in Sub 4, Tab 2. This was first pleaded in May 2020 and amended in the subsequent month 3 times. The last amendment was October 2020. I'm telling you that because the significance of it is that was after the Supreme Court decision in Unwired Planet in August of that year. At that point, Apple seemed to be asserting that the licence shouldn't cover the US at all. And to give my lords some context, at this stage it was running a general point that the licence should only be for patents which had been proven at trial. They were called case-proven patents, so it was patent by patent. They were also running the general point that the Supreme Court in Unwired Planet was wrong. On top of that, they asserted a point specifically as to the US because of the US proceedings. I'll show you that in tab 2. What I'm showing you didn't change in the amended versions. The first page in that tab is an extract from para 18 of Apple's defence, and we see subpara 4A is the argument that the licences should be limited to SEPs found to be valid.
Sorry, could you just tell us what I appreciate quite correctly you've only given us the relevant page, but this is a sub-paragraph of which paragraph?
18.
Thank you.
18 of Apple's defence, and we see from subparagraph 4A the argument that the licence should be limited to SEPs found to be valid, infringed, essential and enforceable by this court. So UK only, and indeed only those patents sued through to judgment. This is patent by patent that we've seen in their policy. The remainder of the sub-paragraph is the alternative, that it's limited to UK patents, but not only those that are sued through to judgment. Can we go forward, please, to paragraph 111 on page 25 of the bundle? Here we see the position set out by reference to the fact that there's a US case, so the licence shouldn't cover the US appeal. See the conclusion in subparagraph C. Next, the position statement filed with the evidence in mid-January 2022, so 5 months or so before the start of the trial. That's Core Volume 3, Tab 3. The first thing to show you is paragraph 39.5. So, my Lord's Chair, turn to page 56 of the bundle. So it's at the bottom, and here we see that not only was the trial F decision being appealed, as I've mentioned, but a point I've also referred to, Apple was contending that the Supreme Court in Unwide Planet was itself wrong as to the decision that the court had jurisdiction to determine terms of a worldwide licence. That was, until September 2023, formally Apple's position in these proceedings. As I've understood it now, they've dropped that. If we go back to pages 54 and 55, we see paragraph 39.3, which addresses the Texas case specifically. That paragraph refers to the Texas litigation and the position that had at that point been reached, the $300 million jury award for all past and future sales. They mention their attempts to challenge that decision, including a request for another new trial and so on. And the paragraph ends by stating that any court-determined global portfolio licence in these proceedings should provide for any final damages award in the Texas case to be taken into account when determining such royalties. Final award that should be taken into account. And that rather dovetails with the position in the US as to Apple having undertaken to pay any final damages award. Let me be absolutely clear, this paragraph in the pleading contemplates that the US proceedings will run their course, and at the end of the US proceedings, Apple will pay the final damages award that they've undertaken to the US court to do, and they assert that should be taken into account. But that's Apple's pleaded case, which has never been amended, that the final damages award should be taken into account. And to be clear, my lords, that is in the first category of cases I identified as to how one might logically deal with the US determination. It is not a contention that the US case should be brought to a halt, the appeals compromised and the judgment set aside. On the contrary, it's contemplating that it would proceed to a final conclusion and that that final award would be taken into account. We responded to that subparagraph, basically agreeing with the substance, explaining how to take the final Texas outcome into account would depend on the terms and the timing of the outcome. Let me show you that. It's tab 4 of the same bundle, page 105. It's paragraph 58. And you see very clearly that we say there should be no double counting. Contrary to the suggestion my friends seek to make, has always been our position. How one takes the final Texas determination into account in this court's licence will depend upon the terms set here in the outcome. So again, contemplating Texas, which had already proceeded to a res judicata judgment, subject to that appeal, would run its course to its final outcome. See that specifically referred to in the penultimate line. Just as an aside, my lords, my friends keep seeking to suggest we're trying to achieve double counting, including by referring to what is said in the US. Double counting is on the premise we've seen, shared by the parties in the proceedings, will be a matter to be avoided by the UK court, not the US. And the fact that we may say in the US this is not an issue here, i.e. in the US, there's no pleading that the sales may be paid for or under licence elsewhere, is not to the point. We accept, when it comes to the UK determined licence, that would be taken account of. They would take account of the final US award. So, my lords, that's the parties' pleading positions. Our responsive pleading was dated the 29th of April 2022, and you'll see that in the bundle index. So that's about 6 weeks prior to the start of the trial, and it remains the position on the pleadings today. I hope my lords can see at this point, very close to trial, we have on the pleadings common ground that it will in due course be a final outcome in the Texas proceedings that happens, and we will need to take that into account in the valuation of the licence here. But how it should be done, neither side descended into the detail on. But what Apple did not contend for in its pleading was that the global licence should provide that the US proceedings should be halted, dismissed, and that appeals compromised or the damages award set aside. Nor, in any way whatsoever, that Apple will be let off the final judgment. In fact, my submission is that the pleading is quite contrary to that. The premise is that there will be a final award in Texas and it needs to be taken account of. And my lords, they just don't have an answer to that point. Certainly it was a notable omission in the note that my learned friend Mr. Turner asked you to read yesterday. And they rather try to portray what they now contend for as within taken into account. They ignore the word final, both in ours and their pleading. What I have in mind there is paragraph 247 of their skeleton, where they refer to that pleading, and in an extremely carefully crafted passage, assert at the point as to the final damages award being taken into account, and I quote, is further reflected as follows. And then they go on to refer to subsequent matters that they set out. In fact, the first thing they identify, this is para 247A, is not subsequent at all. It in fact predates not just both the US trials, so there was no judgment at all, but also before the commencement of the proceedings. They rely on the draft licences offered in April 2018. We just don't understand how it can be said that Apple's plea in the position statement that I've shown you can be further reflected in the licence it offered in April 2018. It's completely untenable in my submission. In subparagraph A, Apple also referred to Optis marking up that licence in April 2022. So that's after their pleading of the position statement, just before we filed our responsive pleading, but at a time when there was a raised judicata judgment in Texas. So strictly, those specific infringement has merged in the judgment, don't require release, although other past acts around the world not subject to the judgment would be covered. As I've already mentioned, after Apple had already indicated its position that the Texas proceedings would proceed to final damages award, that would be taken into account, not released as they now seek to argue is the contention. But again, my submission is that it's quite unreal to look at that in April 2022 as in any way detracting from the pleaded position, both sides, that the Texas proceedings would proceed to a final award which would be taken into account. Now, my lords, the next thing my friend relies upon is a new markup that Apple served, actually by way of an exhibit to Mr. Ankenbrandt's reply, which was the 15th of May, so that's just under a month before the start of the trial. And the first point to emphasise is the pleading wasn't amended, but what happened here was Apple now added a clause that all lawsuits would be dismissed. And more than that, they expressly added wording to include the US proceedings that had proceeded to judgment. Just to make sure my lords have understood, Mr. Ankenbrandt was simply a fact witness, in fact a very minor one, and his evidence was just a vehicle pursuant to which to provide Apple's markup. Now, Apple refer in subparagraph C of that paragraph of the skeleton to Mr. Blasius, Optis' principal fact witness, responding to that statement. And there's an attempt in paragraph 248 and 249 to argue that our evidence was lacking by referring to our position that FRAN terms are what would be agreed between a willing licensor and licensee, and referring to evidence of our licensing expert. Now, on this point, Apple lumped together a reference to static 1, 2 and 3 in para 248, and then para 249 refers to a point Mr. Static covered in his second report. That's before Mr. Ankenbrandt exhibited the further markup. It's notable they don't identify any evidence of theirs to support the contention that it's okay for them to pop it in and get it for free. Not supported by any expert evidence on their side, but they criticise my clients for not having any. But in fact, what they don't refer to, at least not fairly, is Mr. Static, because he did address this late markup in his third report, albeit fairly briefly, pointing out that Apple was asking for more, justifying that it was seeking patent peace without offering what would happen in real negotiations, i.e. reflecting that with additional payments or other consideration. Now, this was a point much broader than Texas, which, as I've said, on the pleadings appeared to be agreed to be let to proceed to a final award and taken into account. Much broader than that. But can I just mention the third Static report, which was the 2nd of June, just before trial, and show you an extract. You need supplementary bundle 2, tab 52. Page 340 of the bundle. And you see para 2 is Mr. Static identified and been asked to look at the exhibit, which is the Apple markup. And you see the general point Mr. Static makes at paragraph 8 on page 341 of the bundle. The amendments Apple make often state the amendments they've proposed are for patent peace. And he goes on to explain it does sometimes happen that a licensee seeks to broaden during negotiation, and he gives examples of the kind of other things that licensees do, or licensors might do, including other patents or covenants not to sue. And he goes on to explain that a licensor would generally expect to receive further compensation or consideration. And he's focusing at the end on the attempt to broaden the products covered. But the thrust of that is generally as to the markups that are there for patent peace. And can I show you one of the amendments in this patent peace category that Mr. Static is referring to? It's the one that Apple are relying upon. So you need tab 48 of supplementary 2, page 327.
Sorry, I wasn't keeping up.
Sorry, it's me.
Where should we be going?
Supplementary 2, tab 48, page 327.
Yep.
I'm just showing you
Yes.
that the evidence that he's given about those that have been included for patent peace includes this one that they're relying upon. You see the comment, which is the Apple comment as to why they want it. And in fact, you see there that the proposed clause was not even a final thing and would need to be considered for updating later. And the thrust of their case, as I understand it, by popping this in, somehow everything changed and that we agreed to it. We didn't. We were proceeding in accordance with the position on the pleadings. In any event, Mr. Static identified that the category of clauses that have been put in the markup were not something that would be agreed to for no consideration. The position on the pleadings remained that there would be a final determination in Texas, which would thereafter be taken into account. And it's rather surprising, actually, without note, that it's my friends trying to shut me out on procedural grounds on the basis of slipping that in, when in fact they haven't changed the pleadings, and the pleadings are something that should actually shut my friend out. Consistent with the position that I've just outlined about it being something that should be addressed later, in closing, we reiterated the same position that it was a matter to be revisited after the court had determined the Fran licence. Each side dealt with it very briefly in 2 and 3 paragraphs respectively. Can I show you that, please? First, supplementary core 5. Tab 5. Page 83. So this is an extract, and we can see the guts of our position in paragraph 292 by the bottom hole, where we reiterate it's for later and give as an example the possible of carving out of the valuation the 5 patents and the US action taking its course. So that's proceeding to final award, consistent with the pleadings. Apple's position in the tab earlier, so tab 4, page 80. We see at paras 720 to 721. The essence of 721 is a bald assertional submission not referring to any evidence at all, arguing it's reasonable for the Texas litigation to be dismissed. It's a new approach, it's the second category I identified yesterday. Advance without any reference to the evidence, something they say is needed. They say it's reasonable, as I understand it, that means that they're implicitly saying it's FRAND. But just let me put down a marker. They are not grappling with the problem for them, that they must show that what my side, the SEP owner, is saying is not FRAND. There's more than one reasonable approach the SEP owner can choose. Now this led to correspondence at tab 16 and 17 of the subcore bundle referred to in our skeleton. But before I show you those 2 letters, Apple's skeleton, paragraph 250, refers to an antecedent letter from Apple. That's tab 15. Can we go there first, please? It's page 197. The relevant para is at the foot of the page. Apple refers to the paragraphs we've seen in our submission and picks out that example we've given as to how the Texas award may be taken into account. And they say it's new, controversial, potentially important, they'll resist it. They identify 2 specific objections. So first is we haven't pleaded it. With respect, that's a poor point from a party that's pleaded the final award for damages should be taken into account. Now wants to say it shouldn't. But as was clear, we had explained in our response that it was just an example as to how it might be taken into account. And the pleading was at the level of generality, saying it would be for the future. The second point they make here is a suggestion we want our cake and eat it by having a global determination whilst also invoking the national claims. That is hardly fair, my lords. It's even more striking given at this point in time, November 2022, Apple was still maintaining a position that separate claims was necessary. And in any event, it's not an exercise in having cake if you're going to avoid double recovery. And Apple ends by saying it agrees it may well require submissions later, depending upon the court's judgment. The next letters to show you, first the one we refer to is tab 16. This is the last page of EIP's letter of the 17th of November. It's the last paragraph of the letter you need to see. We reiterate that we agree that there should be no double recovery in respect of the patents that are the subject of the Texas award. We point out that the suggestion we made in our closing, what you've just seen, is only an example of what might be appropriate. We end by saying, in any event the parties are agreed, this is a matter which should be addressed after the court's judgment. Apple's letter of the 1st of December is at tab 17. The paragraph you want is actually to do in a section to do with ex-Ericsson EDTX proceedings. So it's on a different topic, but the second paragraph introduces this and addresses the double recovery point. So it's the second paragraph just above the bottom hold. And it explains that Optis has proposed that the issue of avoiding double recovery as a result of separate EDTX damages in favour of Optis be dealt with after judgment, and Apple has agreed. Please note those words in brackets well, my lords, and they go on to make a point that the ex-Ericsson patent issues are best addressed subsequently too. My lords will understand it's a similar issue, and as I've pointed out, capable of being addressed in the same kind of way. And Apple is clearly drawing that comparison here too. We're just pausing and taking stock. The position on the pleadings is, as I've shown you, it was common ground that the Texas case would proceed to the final damages award and then be taken into account. How that might be suitably taken into account was not elaborated by either side. Each recognised it may depend upon the judge's determination and the timing of the Texas proceedings. Just before trial, a different approach was adopted in a markup filed by Apple, which contemplated the appeal in the Texas proceedings was compromised and the Texas award set aside, all for no value, said to be justified by patent piece. Mr. Stasic answered the markup by explaining that patent piece additions in that markup would not be agreed for no value.
I should have asked earlier, was he cross-examined on that evidence?
Not that I recall. In closing, that's only my recollection though, my lord, I mean, I might be corrected. In closing, Apple suggested that the new approach of that markup was reasonable, but never argued it was the only reasonable thing. Whilst we gave an alternative which was in fact consistent with the parties' pleadings, because it did allow the Texas proceedings to go to the final award and then be taken into account. But it was only an example. We reiterated the issue would be considered later, and in correspondence, the specific example was objected to, but not the fact that the issue would be addressed later. I've explained why the objections were bad, but in any event, it was agreed the matter was not for decision now, but afterwards. And then what happened is we received the judgment, which on this issue is unaltered in the final form. So on that, the key bits to look at are para 489 on page 493 of the bundle. Cool. This is the judge referring to other proceedings, but not specifically the US, and this is the US judgment. He states all other proceedings must be compromised and Apple gets credit for any money paid. And if there's overpayment, it must be repaid. He goes on, says he's going to consider granting an anti-suit injunction. That outcome, including the mention of an anti-suit, is reflected in the section said to be his binding guide. My lords see that firstly at para 490. It mentions the binding guide, and then within the binding guide what follows 503 to 505 on pages 495 to 496. So notwithstanding the pleaded positions of the parties and the agreement that the matter in any event should be considered after judgment, the judge simply went ahead and informed the parties of his conclusion was that it should all be compromised, the appeal compromised, the US proceedings brought to an end, so you never get to a final award. He did so without hearing the parties on the matter that they agreed was to be addressed later, and he did so without consideration as to what willing licensors and licensees might agree in the specific circumstances where foreign proceedings were not just extant, but a judgment had been obtained at huge expense to both sides, and the final award, so far as it could differ, and could be known for minimal additional costs. And, as I've said, both parties have pleaded that that would proceed to final judgment and then be taken into account. Even worse than that, he went on to impose terms in the licence and his order which have the effect of an anti-suit injunction and are quite wrong. And how that occurred procedurally is a have to say, quite chaotic in my submission. Try and deal with this as quickly as I can, putting it as briefly as I can. What you need to know is this: the consequentials hearing was in July. Prior to that, the parties exchanged position statements. At this point, Apple sought to raise all sorts of worries as to what may happen pending an appeal. He started to suggest we might divest ourselves of the patents pending an appeal. Things like that. I don't know where this all came from, but perhaps it was thought to be a good backdrop to suggest Optis should enter into the licence forthwith, which they also did. One can get a flavour of it from its position statement. That's at Core 3, tab 6. And if you look at page 179, at the foot of the page, paragraph 117, it's the patent divestment point. And if you go back to page 173, you see Apple's proposal A at the top of the page to deal with things in the main consequential issues. This is their preferred proposal, basically licensed now with dismissal of other proceedings, including the US, and the payment by Apple of the licence fee. And that obviously renders any appeal nugatory. That's what they were trying to do. They recognised that, so they had proposal B at the foot of page 173, which accommodates an appeal, and they suggest cooperation with Optis in holding the ring. So just pausing here, this is put forward as an alternative to accommodate an appeal, but required an agreement or cooperation. So it's not directly what the court could or should impose, but it's a proposal that Apple's making that it would be content with involving cooperation, and you see it suggests agreeing a stay of the appeal in the Texas proceedings until after the appeal on the judgment was determined. You see over the page other things Apple say they would do. And under heading 2, over the page 2, is what Apple said about the position in the event Optis sought permission to appeal but rejected its proposal B. And we see it seeks to argue that not entering into the licence immediately would be a breach of undertakings to take the licence determined here. That, as I understand it, involved an unreal attempt to construe the undertakings as excluding rights to appeal. And the argument proceeds that if Optis refused proposal B, the court has jurisdiction to grant what it says is appropriate relief, right at the foot of page 174, which it says can be exercised immediately, they say is attractive. Paragraph 98 suggests Apple will be entitled under section 37 of the Senior Courts Act for interim relief. And what they're talking about there is to join in a motion for a stay of the appeal and cross appeal. So we see what is proposed is clearly an order which is intended to interfere with the Texas proceedings. And the juridical basis for it, I have to say, is not entirely clear from what's set out afterwards, and it doesn't really matter for my purposes. That's what they were trying to suggest. But please note, my Lord, they never actually made an application for interim relief, and that remained the case throughout, even though we kept pressing them, saying, if you want to ask for interim relief, you need to do so, and meet the required standards for anti-suit relief. What happened at the consequentials hearing was we proposed as a practical way forward, hold the ring, that extension of time for 90 days that I referred to earlier. And we also gave a series of undertakings addressing those series of fears that Apple raised, which I suggest had absolutely no basis at all, but the divesting of patents points. I'm not going to ask you to turn it up, but it's in Sup 5, tab 3, the order, where you see the series of undertakings and including saying that we'd ask for a 90-day stay. What happened at that first consequentials hearing, though, was that not everything was covered. But not long after it, we got a draft judgment on the 7th of August, and the status of that is quite obscure because it was never finalised and handed down by the judge. Instead, what happened is that there was a further consequential hearing fixed, relisted for a further hearing, albeit we knew the substance of the judge's view on many things before that second hearing, because he'd sent the draft. And around that time, the judge asked Optis to address the question of whether he could require Optis to sign the licence immediately, because he was at the time interested in writing to the US court. That was in August, and he asked for Optis to do a note in 7 days, and I think he gave us a little bit of extra time, 10, although he never addressed the contents of it, and as I understand it, Apple never responded to it. Because this was taking so much time, we had to write for another 90-day extension, which, as I've already foreshadowed, was dealt with by the court by giving a 90-day stay. And in the run-up to that second hearing, Apple was again suggesting it might seek interim anti-suit relief. And we again asked for an application if it was being made, but none ever came. I should mention that in parallel, at this time, as an alternative way to deal with the matter in the interim, the parties entered into a debate about the possibility of an escrow to hold monies payable under the final award in Texas, which it was anticipated would, or at least might, become due before the appeal in these proceedings. We always made it clear that we never wanted anything irrevocable to be done, and the debate over the escrow concerned details of how it may be held, who had control of it in terms of which court and so on, and it wasn't resolved. For your note, I'm not going to ask you to turn it up, but at Supplementary 5, tab 28, there is a rival coloured text as to what the details of the escrow should be in an order that was prepared before the hearing. It's page 114. But of course it only mattered as an alternative to interim relief. And as things turned out, Apple never did seek interim relief. No application was made, and indeed, as I understand it, the learned friend Mr. Mercer stood up to disclaim it at the second hearing, which led Mr. Raphael, who was in my place, to indicate that all that text in the draft order didn't need to be addressed. So that seemed to be the end of it. And we suspect Apple recognised the problems with the anti-suit application, and that the better course was to keep a stay, to seek a stay in the US by applying in the US. We don't know, of course, but the point was dropped, and the rival contentions on escrow went away as well. But then, my lords, we received a draft order and the consequential judgment at the start of February. And in fact, there were two versions of this in the draft judgment. So at the top of the August version, there was one right at the beginning of February and then one on the 11th. And then there was a further hearing on the 13th. And the judgment, which changed again, was actually handed down on the 14th. I was going to take my lords to what happened at that hearing. Because of time pressures, I don't think I will. Can I just ask? Actually, let me first of all deal. No, let me move on. Can I ask my lords in due course to look at the transcript in Supplementary 4, tab 6, page 155 of the bundle, picking it up at page 6 of the manuscript, all the way through to page 164 of the bundle, page 43 of the manuscript. It's worth reading to see my learned friend Miss Jamal seeking to persuade the judge to take out the injunction, seeking to the judge to understand that if he was holding the ring, he needed to hold the ring both ways round on an appeal, where he was absolutely only interested in preserving his own judgment rather than what might happen on appeal. That's what happened through that transcript, but unfortunately I don't think I can take up time now to take the lordship through it all. It's quite extraordinary in my submission when you read it.
It's tab 16, tab 6.
Sorry, I'm corrected. I said tab 6 and it's tab 16. What I do need to take my lords to is the SAS case in the authorities bundle at tab 8, authorities bundle 3 tab. This is a case where a judgment had been obtained in the US against WPL for both breach of contract and fraud. Because WPL had acquired a licensed copy of software but used it covertly for the purpose of studying it and producing a competing product. And that was in breach of the terms of the licence. The claim in the UK failed because of the provision in our law rendering limitations on use like that void. But the US claim, which WPL defended on the merits, succeeded. Because of the conflict, the decision in the US would not be enforced by the English court, and the dispute being considered in this case was about enforcement of the US judgment in the US, and the extent, if at all, that the UK court could anti-suit SAS from enforcing the US judgment in the US court. The basic point as a way of enforcing the judgment was to secure orders for assignments of debts owed. And so there was an issue there about, well, what happened if the debtor was outside of America, and in particular, what happens if they're in the UK, so you're in effect getting an enforcement against assets in the United Kingdom. We have nothing like that complication in our case, but the judgment has a very helpful explanation of the approach to anti-suit or anti-enforcement injunctions and comity. Can we look at the section on comity, please? It's at page 402, just at the top hole. And we see first a reference to comity being an important consideration. At para 101, we see reference to the respect for the work of foreign courts, particularly in countries like the United Kingdom, like the United States, which share a common principles and the high regard for the rule of law. You see the well-known passage of Lord Justice Torson in Deutsche Bank at paragraph 102, and we see Lord Justice Miles Gazon, this is paragraph 103 at the top of 403, to refer to it being evidence that the anti-suit injunction that had been granted in the case was viewed by the US courts as an unwelcome interference with their process, which is a cause for concern and regret. 104 moves on to make an important point about the relationship between comity and delay. And the point is, the greater the delay in seeking relief, the further the foreign proceedings will have advanced, and the more justifiable will be the foreign court's objection to an order by the English court which frustrates what's gone on before and wastes their resources. This is a really important point, of course, and Lord Justice Miles quotes the passage from Lord Justice Christopher Clark in full on this. The quote extends almost 2 full pages, and he quotes it in full because he says worth it. And it is. That quote, I'm not going to go through it now, again because of time, but that quote makes it absolutely plain that a really important part of the consideration of comity is the extent to which foreign proceedings have proceeded, and interfering with them will cause will cause a waste of significant resources in foreign courts. The actual dispute in SAS was slightly more nuanced than the one we have here, because what you see in the judgment is that they say it would be absolutely far too late for an anti-suit to stop enforcement at all. The only thing they were interested in was the enforcement by getting assignment of debts that would be UK assets, and they said that was different. But the actual substance of the decision on how the delay would be far too great, emphasises that when you get to a position where you've got judgment, anti-suiting a foreign court really is an affront to comity, because you're wasting a massive amount of resources.
So that's 115 you're referring to, I think.
Exactly, yes. Now, can I draw together, so that as quickly as I can, so that I don't get into trouble with Mr. Abrahams, that what I say the errors are the judge made in regard of this treatment of the US proceedings in this case. There are 3 types. First, there are the complaints as to the licence, in particular the judge's conclusion to ignore the US res judicata judgment, Apple's undertaking to that court that it would pay what's due under that judgment, and to incorporate terms in the court-determined licence here that fail to take that into account. That wrongly requires compromise of that judgment without any value and other terms which wrongly constitute anti-suit relief. That's ground 23 and in part ground 14, which we raise as to what willing licensors and licensees would not agree. And actually, it's raised what willing licensors and licensees would agree is raised by the respondent's notice. So those grounds in our grounds of appeal and respondent's notice engage these aspects. The second is the provision in his order, specifically those that amount to an anti-suit injunction. That's ground 24. And third are the procedural unfairness aspects, which is ground 22. Can I do that one first? So the procedural issues. There are two separate points. The first in time was the way the judge simply decided that the Texas proceeding should be terminated in his judgment without regard to the fact the parties had agreed it was to be a matter addressed later. That's the point we elaborate in paragraph 202 of our skeleton. And it's no answer to that point in my submission for Apple to say they had an argument that a particular way in which we had, by way of example, suggested things might be taken account of, they would seek to argue we were shut out from, because we didn't even have that argument. But as I've pointed out, it was only an objection to a particular example we put forward. It was a bad objection, but we didn't even get to have the argument. The judge just simply went ahead and decided what he did without hearing the parties, and the court-determined licence specifically records that clause 7 is intended to carry into effect the approach he identified in paragraphs 503 to 505 of the judgment. So in similar vein, and this is the second point, he simply came up with paragraph 6.2 in his draft after the consequentials hearing, even though Apple didn't apply for interim relief. That's what we raise in para 177 of our skeleton. That interim provision is plainly intended to interfere with foreign proceedings, and he presented the parties with it as a fait accompli in the order. And when you read the transcript that I've asked you to read, you'll see the attempts to get him to reconsider fell on deaf ears, and in fact he said he'd already decided it. And it's even worse, my lords, because Apple's climb down over interim relief meant that it was just not a live issue before him at that point in time. So those are the procedural issues. We say they, in my submission, they're serious, and this is not the way litigation should be conducted. Can I deal very briefly with the substance of para 6.2? This falls in the section of our skeleton we set out at paragraph 225 onwards. It's absolutely plain in my submission. This is an injunction, and its purpose and effect is to interfere and hinder the progress of the US proceedings. When you see what the judge called it in that transcript, he said it was a court monitoring process. And there are aspects of that transcript where it makes it look as if he's deliberately making it vague so that we have to come back. Anyway, it's clearly an order that's purpose and effect is to interfere and hinder the progress of the US proceedings. It is in the nature of an interim anti-suit injunction or anti-enforcement injunction, included without any protection of a cross-undertaking. The judge plainly thought it was for him to decide what happened in the US proceedings, and that, with respect, is quite wrong. And it's particularly egregious given the huge resources that have been expended in the US, both by the parties and the court itself. The judge is in effect telling the US courts that to press on and determine the appeal, or indeed to do anything further in their proceedings, was something he considered shouldn't happen, and that he knew best. And given that my clients made it absolutely clear they're not and would not wish to cause any irrevocable step to occur, there was no need for it. So that's that paragraph 6.2. That leaves the provision in the licence itself. And on that, the judge, if he'd heard argument on the matter, instead of simply deciding it beforehand, would have appreciated that the pleaded case of both parties was for there to be a final award in the Texas proceedings, and for that to be taken into account, rather than the licence to provide that the appeals be compromised and the judgment in Texas to be set aside for no value. The former course does not require evidence to value of compromising the appeals and setting aside the judgment, because you don't do it. But Apple seeks to contend for the opposite, and they say that it ought to be done gratis, and they do it without any evidence themselves as to how that would happen. My Lords, the approach that was common on the pleadings, so not terminating the US proceedings, also has the happy effect of not raising any of these comity issues that the contractual terms in the order and order 6 paragraph 6.2 of the order have. So the happy effect of that actually is that all of these comity issues that the anti-suit gives rise to for the same reasons go away. And my Lords, there is one single crux point on this that I foreshadowed earlier, and that's this. It's not good enough. And if the judge had actually heard argument on this, he would have realised it's not good enough for Apple simply to suggest that their proposal is reasonable. They must show that the alternatives we put forward, that of there being a final award, that it's taken into account one of the two ways we postulate to avoid double counting, are not reasonable. And that they can't do. Indeed, I don't think they even try to do it. And the reason that is key is because the FRAND obligation is ours, and if there are alternatives, Optis gets to choose. So we submit our approaches at the very least one of the FRAND approaches. And it's difficult for my friends to say it's not, given that that's their case all along, and still is their pleaded case as to how the Texas proceedings should be accommodated. And if I'm right about that it's a FRAND approach, we can have it. I've taken that out of real canter. Do my Lords have any questions on it?
No.
Then I will let them stay, Brands.
Mr. Hayes.
My Lords, I'm addressing grounds relating to the terms of the court-determined licence, or CDL, which the judge annexed to his final order of the 16th of February. We'll go into that in just a moment.
And this is another one where he ignored what was common ground between the parties.
There are I'll be making that point a number of times, my Lord, yes. So, grounds 11 to 13, which I'm going to take as an interrelated set, relate to the fact that the CDL is not a commercial contract or anything like that. Instead, it's a short-form framework document. It creates a trilateral relationship with the court having ongoing involvement as the supervisory party. Now, as my Lord Justice Arnold has averted to, that was neither party's choice. At trial, both sides put forward long-form commercial contracts, which they contended were FRAND, and both sides engaged with the others. So there was a trial bundle which contained each side's form and then each side's markup of the others. After the judge handed down his main judgment, the parties produced a composite long-form draft licence, reflecting the determinations made in the judgment. And in the usual way, text that was agreed to follow from the main judgment was in black, and where there are outstanding disagreements, the rival texts were in different colours, blue and green. So that document, you don't need to go to it, but for reference is in Sup 1, tab 19. What followed was a series of consequential hearings, as Mr. Speck has referred to, spread over 8 months, which considered the licence terms. So we had 3 days in July 23, 2 days in December 23, and a final day in February 24. Those hearings also considered the confidentiality issues, so that that time wasn't entirely taken up with licence terms. For the first, the July 2023 consequentials hearing, the parties provided really detailed written and oral submissions on the areas of disagreement in the composite long-form licence, and both sides anticipated that the judge would go through the disagreed text in the composite licence and determine the final text. Now that was the process that was done in the previous 2 cases, where the Patents Court has settled a FRAND licence. Mr. Justice Birss, as he then was, if I may refer to your Lordship, and Mr. Justice Mellor were provided with markup composites, and I understand they went through them in their rooms, having heard arguments saying, yes, this is the right term, this is the right term, and so on. Instead, what the judge did in August 2023 was circulate a draft consequential judgment which addressed some of the disputes, but only ever at a high level, not at a textual level.
And it was because he hadn't settled the FRAND licence that we had to have a further hearing in December 2023. And for that hearing, the parties produced an updated composite draft licence. So the updated version is worth glancing at. Supplemental number 5, tab 27. My lord, what you see from that document is, first of all, that it looks like a proper commercial agreement as willing licensees and willing licensees would agree in real life. For example, clause 1.1 on page 92 defines affiliates, which is used in the context of the parties, the definition of the parties, so that both parties would know precisely who on their side and on the other side was covered and not covered by the licence. And you see the second point is that, and a lot more besides, is in black. Lots of black text here that's agreed. That's obviously subject to any questions of appeal, but that was agreed issues for him, the agreed text for him. And again, for the December 2023 hearing, the parties produced really detailed written and oral submissions on the remaining areas of disagreement. The parties were still expecting the judge to resolve the textual disputes in the orthodox way. However, the outcome of the December 2023 hearing was that on 2nd of February, the judge circulated an updated draft consequential judgment, together with a set of short form terms, which were entirely new and adopted a wholly different approach, as I'll show you, and which he had drafted himself without giving any notice that he was planning to do such a thing. He described his short form terms as, quote, radical departure from what the parties had proposed, unquote. So a further brief hearing was convened for the 13th of February to finalise the final order and CDL, and my learned friends asked you to read quite a big chunk of the transcript from that hearing, but the judge made it clear that his radical new approach was not up for debate, and that the licence terms themselves were not to be the subject of extensive further argument, but rather for tweaking. Okay, and I'll come back to that point. So, the final version of the licence produced by the judge, the CDL, is in Core Bundle 3. We may go to that. Tab 10. In tab 10, pages 350 and 351 is the licence, the CDL, and that incorporates by reference the order which is on the previous 2 pages. Now obviously this is nothing like a bipartite commercial contract. As I say, it's a tripartite framework, and you see that in a number of places. Let me show you. First, from paragraph 6.1 and 7 of the order. So that's we're on pages 348 and 349. Let's look at 6.1 and 7. And the reason why the judge's short form CDL requires such ongoing supervision is because it leaves so much unresolved. So an example of an unresolved issue is the fundamental issue of the identity of the parties to the contract. So you see clause 1, page 350. Okay. Associated companies to be determined in case of dispute by the court. So the parties obviously made detailed submissions on who should be bound by the contract on each side. The judge simply declined to resolve that issue. He simply used the open-ended expression associated companies and said that, that would be what that meant would be determined by the court as and when the issue arose. And you can see also from clause 9.2 on page 351.
On what basis?
I'm sorry?
On what basis would he do that?
Well, presumably what he considered at the time would be FRAND for someone to be included or not, I guess. I mean, I'm going to show you the bits of the judgment where he explained why he should have this ongoing supervision. And it doesn't make for edifying reading, my lord. Clause 9.2, the definitions may be varied with the written approval of the other party or the order of the court. So he was retaining the ability to vary the definition, vary the identity of the parties in clause 9.2 of the CDL. Obviously, no willing licensee or licensor would leave such important matters vague for the decision at a later date of a third party, even an English High Court judge. And further examples of this approach can be seen in clauses 3 and 7. So what we see in clauses 3 and 7 is, instead of defining the parties' rights and responsibilities, there are cross-references to the open-textured statements of principle in the judgment, and then an ongoing role for the court in supervising and working out how those principles would apply in practice in individual cases as they arose. Clauses 3 and 7. And a further example is the provision on assignment, clause 9.1. Again, we had a lot of submission on the requirement of assignment when the contract could and couldn't be assigned. And of course, a commercial contract would provide real clarity as to exactly the circumstances in which it might be assigned. And instead of resolving issues, the judge retained to the court the right to decide if and when it can be decided, and on a case-by-case basis as and when it arose. And the vice of this approach is not just that the wording is vague, so that the parties might end up having an argument, is that the contract intentionally leaves issues unresolved to be decided later by the judge. And the CDL also contains clauses that neither side asked for. I point to clause 6, that prevents Apple from challenging the validity of foreign patents, which neither side wanted, contrary to the basis on which the court acts in FRAND cases. Clause 5.
It's contrary to Supreme Court authority, isn't
Correct, my lord. For your lordship's reference, footnote 141 to our skeleton argument gives you the references on that point. But your lordship is absolutely right, which is why we never asked for it. Clause 5.1 provides for the licence to cover all products and components supplied by or to Apple. That's far wider scope than either party was contending for. That's the subject of our ground 14, which I'll come back to. That was much wider than Apple was asking for. And that's obviously a consequence of the fact that the judge was drafting his own CDL from scratch rather than resolving the issues identified between the parties. Okay, so our grounds of appeal on this are: first, ground 11, is that the judge misunderstood and misapplied the role of the court in determining FRAND terms. When the court declares FRAND terms, obviously its role is to establish a set of terms which, if the SEP owner offers them to the infringer, they meet their obligations under the ETSI IPR policy. And that's clear from all the authorities, particularly Unwide Planet Supreme Court, indeed all three of the Unwide Planet judgments. Moreover, the judge didn't apply, he completely ignored the well-established principle that a range of terms may be FRAND, and the SEP owner complies with its FRAND obligations by offering any one of those terms. So that principle, of course, means that the judge should have asked himself whether the detailed commercial terms put forward by Optis were capable of being FRAND, and only if he determined that that answer was no, and only to the extent they departed from FRAND, could he substitute different terms. And he just didn't attempt that exercise at all. He didn't acknowledge the exercise, he didn't attempt it. My lord, where the judge explained what he was doing and reveals that he was applying the wrong approach is in the consequentials judgment, which is in Core Bundle 2. Tab 1. If I pick it up at page 42, paragraph 74 explains the nature of this jurisdiction in terms of the court imposing FRAND terms on the party as a result of a finding of infringement. I'm sorry, my lord, if I'm going too quickly. It's page 42, paragraph 74 and the heading to paragraph 74.
Yeah.
Yeah. And what he's explaining here is that the court, he's explaining a jurisdiction under which, because there's been a finding for infringement, the court can impose licence terms on the parties. And that is just simply not the nature of the jurisdiction and is contrary to all the authorities on FRAND. And the judge repeatedly referred to the court imposing a FRAND licence on the parties about, he used that term over half a dozen times in his two judgments. I'd also draw your attention to page 45, little Roman 5a. He says, where the parties are agreed that a certain term is FRAND, even if there are alternative FRAND terms, the court should be slow to impose other terms not agreed by the parties, even if these are also FRAND. Sorry. I'm on page 45 of the bundle, my lord.
Yeah.
Little Roman 5a, and the footnote 92, which also makes clear that he considers that he has the power to impose terms that neither party wants, and that makes clear that he's proceeding on the wrong basis. So too...
Why does the fact that he decides that terms that neither party want to FRAND mean he's on the wrong basis?
Of course, if he decides that neither party's terms are FRAND, then of course he can proceed in that way. But where the parties have agreed something, there's simply no basis for him to say that it's not FRAND. If both parties agree it's FRAND. And B, on page 45, makes clear his error. Where the parties are in disagreement, the court will again have to consider whether both parties putting forward FRAND terms or only one. That's wrong. The court doesn't have to consider whether the implementer's terms are FRAND, unless and until it's first concluded that the SEP owner's proposed terms are not FRAND. And then, to answer my Lord's question on what basis does he think he can act in this way, I think the closest we come to an answer is paragraph 86 of this judgment on page 47, where this is where he's explaining why the court shouldn't exercise what he calls a self-denying ordinance in terms of how it intrudes itself into the affairs. Oh, sorry, it's other jurisdictions, I'm sorry. But he's talking here about the ongoing role for the court. Now, I'm not going to attempt to summarise paragraph 86 because I don't understand it. But what is clear is that he is quite deliberately not settling the terms of a self-standing commercial contract. Instead, he's imposing a framework for a court-supervised relationship on the parties. And that's obviously an error of principle because that's no part of the court's role in a FRAND case. Ground 12, I've already made that point. Ground 12 is that it was an error of principle not to settle a commercial type long form license because a willing licensee and a willing licensee would agree a full-length detailed commercial contract, just like the composite license, which was mostly agreed. Companies want legal and commercial certainty and to understand their respective rights and obligations in all foreseeable scenarios. They would not agree a framework which leaves important matters unresolved and for later resolution by the court. Then under ground 13, we say that the judge's whole approach to formulating his CDL involved a serious procedural irregularity. As I've explained, Optis was given no notice that the judge was considering his, quote, radically different, unquote, approach, under which he just declined to resolve the issues identified between the parties. So Optis was given no opportunity to take issue with the premise of the judge's short-form CDL with its ongoing court supervision and lack of detail. Now, it is right that after he produced his short-form licence, he did invite a certain amount of submission on the wording, and that took place around the hearing on February the 13th. But he didn't entertain any discussion of the principle of the short-form supervisory framework in place of a proper long-form commercial contract. And I'll give you the references to that in a second. And that was a serious procedural irregularity because it involved making an important decision of principle without giving Optis, or indeed Apple, any notice or chance to make submissions about it. Now, I need to address briefly 4 ways in which Apple seek to defend the judge's approach in relation to grounds 11 to 13. First, Apple says that the judge invoked the goal of patent peace. Now, we accept, of course, that one of the goals of the willing licensee and willing licensor would be to avoid future disputes so far as practicable during the term of the licence. But that goal would not trump their other commercial interests, and more importantly, doesn't trump the principles of FRAND licensing identified by the Supreme Court and this court in various cases.
Well, you could never have a licence that was subject to renewal. To have patent peace, any FRAND licence would have to run to the end of the last patent in the portfolio.
No, I agree, and no doubt your lordship could think of other examples of that, and we all could.
In the real world, that's not what parties do.
No.
I mean, they frequently agree amazingly short ones, which is another problem, but that's by the by.
Yes, let's not get into that, but your lordship is absolutely correct. Second, Apple points to what the judge said about the degree of commercial mistrust. I should have asked you to keep paragraph 86 of his consequential judgment open, because it's there he deals with that and I need to comment on it. So it was paragraph 86.3. If you still got that. And on page 48 of bundle core 2, you've got that. And he says at the end, because of the commercial mistrust, he says in the last sentence, therefore seemed to me appropriate to revert to an agreement that sets out the essentials but leaves scopes for disagreement in regard to carrying out the agreement into effect to return to this court.
So why is the commercial mistrust higher in this case than in the other FRAND dispute?
It's obviously not. I was going to make a more fundamental point, my lord, which is that this reasoning is not just irrational, the opposite is true. The more commercial mistrust, the more it was incumbent on the judge to resolve the issues in dispute, to give the parties clarity and certainty as to what their rights and responsibilities were. And the judge's logic falls apart completely in little 4 on this page. He says the greater the opportunities the parties have to bring matters back to the court, the less I anticipate those opportunities will be used. Again, the opposite is true. The reason commercial parties always enter into detailed commercial agreements is because they do not want to have to litigate. And they know that the greater the areas of uncertainty and the more left unresolved in the agreement, the more likely they'll have recourse to the courts. And it's so bizarre because anybody who's ever done a commercial contract interpretation disputes know that the vaguer the contract, the more the scope for dispute. So, in fact, the judge's open-textured CDL makes litigation peace less likely. Third, Apple relies on the judge's comment in the consequentials judgment, this is 103, we don't need to go to it, that there was a proliferation of disputes, and he said it was like a hydra. But the problem was that the judge never engaged with the disputes on the composite license. He never worked his way through the disputes, as other judges have. If I put it like this, the dispute may well have had many heads, but the judge never attempted to cut any of them off, and that was the problem. Fourth, Apple says that the judge invited Optis to comment on his draft commercial license. Now, this is a bad point, and the way we've dealt with it to save time is to collect the references in MOS 42, which is in sub 4, tab 1, 15, paragraph 23. Mr. Speck correctly described this process as chaotic a few moments ago. We've given you all the references to the various documents and submissions. But the key points are these. First, as I've said, Optis was never given the opportunity to address the fundamental question of whether there should be a proper commercial license or instead a framework. I've noted that in Apple's short note, they tried to give a hint that in the December 2023 hearing, the judge gave a clue that he was considering a short form CDL. That's a bad point. He gave us no inkling that he was considering a license. There was only 2 pages in total. On the contrary, he entertained detailed oral submissions on the terms line by line. I strongly recommend that you don't read those submissions in detail because they're so uninteresting. But just for reference, the transcript is in Sup 5, tab 12, page 53. Starts at line 217 of the manuscript. You have Mr. Raphael and me addressing these composite license terms in great detail, and no point the judge saying, no, hang on, let's not bother doing this at all.
Mr. Abrams, I'm so sorry. Can you give me the reference to what bit of Moss 42 it was you wanted to?
Yes, paragraph 23.
Paragraph 23.
Page 14.
Is about discounts
I thought you were on 25.
Past sales.
I thought you were in 25.
25, you're right. I'm in 25. I am. I don't know why I said 23.
I think you did say 23. But that's
I think I did, yeah.
Thank you.
Well, whoever wrote my note, it's their fault. No. And as you see on page 7,
Oh, well, that's fine.
you've got it now. And I've given you the additional reference to...
Yeah, so by way of example, you have little e,
Yes.
where the submission is made in broad terms, our positions, your literature, her detailed arguments about fully worked out commercial terms, and you get a dusty answer of the judge, I'm not doing that, end of.
Indeed, and you get it again, and F, you get similarly dusty answers. That was Ms. Jamal suffering that on that occasion. Optis relies on Ms. Jamal saying at that hearing also that the judge's draft fits the bill, and we just give the context for that comment at H and I. What was happening was that having done the short form license, Apple wanted to incorporate various terms from the long form license and said, oh, these are agreed, so these can just be cut and pasted in. And Ms. Jamal was saying, no, you can't just cut and paste little bits of the long form into your short form. It just doesn't work like that. If you're going to have a short form, then it needs to be the short form with court supervision, not this hybrid. So that's I don't know if they're going to rely on the fit the bill comment orally, but it was in that context of avoiding the hybrid that she made those comments. And finally, as Mr. Moss says in his 25, as he says somewhere in this document, with this judge, there's frequently real uncertainty as to what is and is not still open for discussion. So at no point is it ever a good point to say, oh, well, you should have argued with the judge over this point or that point, because it's never clear when you're allowed to do that or not. And in fact, that's a point that's going to recur in the next few moments. My lords, if you're with me on any of grounds 11 to 13, then the solution is that once this court has resolved the points of principle of all the grounds, then the parties will produce an update of the composite licence, and then to the extent that there's any rival text that remains, the court will go through that in the way as it's been done before, with the benefit of such further submissions as it wishes to invite. My lords, that's grounds 11 to 13. Now to ground 14. Ground 14 relates to the fact the CDL gives Apple various rights and benefits which were not factored into the valuation exercise, so they are effectively rights for free. There's actually no separate decision for your lordships to make under ground 14, but I'll need to explain why very briefly. Ground 14 has 3 limbs. For reference, those are set out in paragraph 29 of the grounds of appeal. There's no need to look them up, I'll tell you what they are. So lim little Roman 1 concerns the overextensive scope of the licensed products in clause 5.1 of the CDL. As I said a minute ago, it was common ground at trial that the licensed products should be limited to end-user products and shouldn't include intermediate products like chipsets. But the judge nevertheless ordered them to be included, and that's a manifestation of our complaint on grounds 11 to 13. Not surprisingly, this lim of ground 14 is conceded by Apple, so there'll have to be an adjustment to that clause at least. Lim 2, little Roman 2, concerns past sales prior to 2017, which the judge gave to Apple for free. That overlaps completely with ground 10. Again, not surprisingly, Apple concedes this lim at this level at least. And then lim 3 concerns the US position, and that's been addressed by Mr. Speck. So that's where we are on ground 14. My final ground is ground 17. That's the interest stop date. Okay? So that is that the judge was wrong to adopt the 1st of January 2023 as the cut-off date at which interest would stop accruing. That date was arbitrary and no reason basis was given for it in the judgment. Now, we know from judgments of this court and the Supreme Court that the purposes of interest are twofold. One, to disincentivise holdout. Two, to ensure that SEP owners are properly compensated for being kept out of their money, which they should have started receiving as soon as the implementer started using the patented technology. And those purposes are undermined if interest stops accruing 2 or more years before the SEP owner gets their money. Now, just to be clear, Apple could always protect itself by paying money into court, and we fully accept that no interest accrues in respect of any portion of the licence fee once it's been paid into court. So we accept that interest stopped running against Apple on the 63.7 million which it paid into court on 28th of February. It's common ground that that wasn't enough money, as it were, but interest stops running on that amount, on that date. Now, as I said, the judge gave no reason why interest should stop running on 1st of January 2023. Apple seeks to justify it on the ground that the delay in payment is due to Optis appealing. That's paragraph 17 of the respondent's notice. But that's no justification at all. Optis took the view that signing the licence or accepting the money into its own hands could prejudice its proceedings position in ongoing proceedings, i.e. this appeal and all the US proceedings, and that was a completely reasonable position to take. To the extent that the judge's cut-off date disincentivises or disadvantages Optis for appealing, it's contrary to the rule of law. Now, I need to address I need to address Apple's respondent's notice ground 4, which contends that Optis made no submissions on the cut-off date. And we've dealt with that in MOS 42 at paragraphs 26 and 27. So if I can just adopt those paragraphs and just tell you that the most important...
MOS 42,
MOS 42,
paragraphs
26 and 27.
Yes.
Now, we agree, everyone agrees that the judgment indicated a cut-off date of 1st of January 2023, the main judgment that is. It did it in a somewhat elliptical way, but everybody understood him saying that. And the references, they come from 57 and 501 of the judgment. That's referred to in paragraph 27. I won't take you to those since everybody agrees that that's the effect of those paragraphs. Apple relies on the words at the end of 502 of the main judgment, where he said that he used the phrase "firm but provisional view" in relation to the rate of interest. That paragraph 502 did not concern the cut-off, and we did not.
Sorry, can I just try and understand what's the argument that you're trying to meet in the respondent's notice? Is it that you waived your procedural rights? Is that the argument?
I think it's put like this. The judge indicated a firm but provisional view in the judgment. We had a choice, either accept that or argue with the judge about it. But what we couldn't do is say, okay, well, that's the judge's firm but provisional view, shrug our shoulders and then come to this court.
So you waive your procedural rights and you're debarred from appealing?
Yes.
Is that the argument?
Yes. Yes, I think so.
Staggering.
Indeed. And our points are, One, it wasn't a firm but provisional view about the cut-off date. That wasn't provisional. Two, as my lord has put to me, it is a staggering submission that when a judge comes to a firm but provisional view, that you have to then argue with the judge. You can't just appeal on that. And three, we didn't understand the judgment in that way. If we got it wrong, if we misunderstood the judgment, that should not be held against us. As I said, it is not easy with this judge to know what is and is not open for argument. If we got it wrong, which we didn't, but if your lordships think, oh, actually, I think the judge would have listened to you if you'd have argued about that, that is not a reason to shut us out now. The result of the cut-off date of the 1st of January 2023 is quite wrong in principle. And the fact that we didn't address further argument of that because we didn't think we were allowed to is not a reason to allow that to go uncorrected. And all those are my submissions on those grounds.
Thank you very much.
And that concludes our Optis' submissions.
Thank you very much. Mr. Turner.
Will you give me just a moment to arrange myself? Please the court. Mr. Mercer and I are going to share the oral submissions for the respondent, Apple. He will deal with the grounds relating to the issue of the parallel US proceedings. Those are grounds 23 and 24, and in substance, ground 23. I'll address the other grounds. Substance, ground 22. By way of roadmap, I propose to organise Apple's submissions in the following way. First, make headline points on Optis' case in this appeal as it's been developed in writing and orally. Second, I'll address the fundamental criticisms levelled at the judge in Optis' ground 1, which were really caught up in my learned friend Mr. Speck's general address over the last couple of days, and that is the judge's supposed failure to understand or apply 5 basic principles of a FRAND determination, which Optis says has led to all or most of the problems in his assessment. Third, I'll deal with the first group of Optis' grounds of appeal. That spans grounds 2, 3 and 4. Those are the grounds directed to the proposition that the trial judge, his whole approach to determining a FRAND value for the Optis portfolio was wrong in law, as well as procedurally unfair to Optis. If I may pause for a moment, it's important to be clear at the outset about precisely what Optis is contending concerning how to do FRAND valuations. If we could please pick up Optis' skeleton.
Just before you do, you were giving us a roadmap. Are you departing from? This can't be the end of the roadmap.
This isn't the no. This isn't the end of the roadmap. I'm just taking it in stages. I'm pausing here in the roadmap to just show you.
Why don't finish the roadmap first?
Well,
a bit easier to
it's just easier to get down a list of where you're going, and then.
No, I'll if your lordship wish. So third is to deal with grounds 2 to 4.
Yeah.
And as I say, those are the submissions that the judge got everything totally wrong. Fourth, I turn to the second group of Optis' grounds of appeal concerning valuation of a FRAND licence to Apple. That's grounds 5 to 9. Fifth, I'll tackle the complaint by Optis about anchoring or apparent bias in the judge's valuation exercise. Sixth, and last, I'll deal with Optis' grounds about the judge's approach to the non-royalty rate terms in the court-determined licence, which Mr. Abrahams has just addressed you on. So if I may, then I'll just make some comments before I turn to the headline
Yes.
points. In relation to the first group of grounds, what I wanted to do was just to be clear about exactly what the contention is. We'll go on to address them in a moment. And for that purpose, if I may, we could pick up Optis's skeleton. Core 1, tab 4. And they pick this up on page 75. It's the heading above paragraph 88. And you'll see the way they put it is that the correct approach to valuation, they say, by which they mean this is the only correct approach as a matter of law, is to identify specific comparables, and what they go on, as you've heard from Mr. Speck, to submit is that one must aim above all to use licenses to the Optis portfolio itself, on the footing that this is the subject portfolio now sought to be determined in these proceedings, and then to derive from those comparables a per unit royalty rate for a court-determined license to Apple. It's a very succinct way of putting it, but that's, as we understand it, what the case is. And the way it's put is that it's essentially an error of the law for the judge to have done it in the way that he did. And I shall address you on the point that the judge's essential approach, which we've now heard a great deal about, was not madcap. It was not based on a fundamental confusion that there was a lump sum approach to estimating a FRAND royalty, which was, to use Optis's words in paragraph 78 of its skeleton, strictly distinct from establishing per unit rates, whether those are dollar per unit or on an ad valorem basis for the handset. Now, it is true that this was not the approach that was adopted either in Unwired Planet or in Interdigital, but it was responsive to the particular evidence that was led in this particular case with its features and the findings that the judge made on that evidence. And then, based on the proposition that this court should essentially tear up what the judge did in this appeal, although not something submitted in the court below, Optis is now putting forward a positive case that this court on appeal should decide that there are potentially two key comparables, and those are what the judge should have focused on, or more accurately, what this court now, given the situation, should focus on. The first of those is the license to Google, and I would observe that this single data point has become, at least in the course of argument yesterday, Optis's primary case. Although Google is a large company, self-evidently, our essential point, which I will develop, is that this license was granted in return for making a lump sum payment to Optis in the same ballpark as the costs of FRAND litigation, since it concerned a small volume of device sales on Google's part. And I'll return to that and its significance when you are considering the importance of this as a freestanding comparable. The other is the license to Apple from Qualcomm. The point we made below was this. It was that Qualcomm is an undertaking whose patent licensing practices, including in relation to Apple itself, have been the subject of controversy globally under competition laws because of a concern that it is leveraging market power in a separate field, which is the supply of the physical chips, the cellular chipsets, into its licensing practices, and so achieving an artificial inflation in the licensing rates. Now, this point was put forward by us, by Apple, as the context for direct witness evidence that was led by Apple at the trial about the specific events that had led to Apple paying Qualcomm the rates that it did. And to be clear, that was the prospect that Apple could be denied in short order a supply of chipsets that it urgently needed to secure. And if I may invite you at this point to pick up the main judgment at paragraph 263, which Mr. Speck has referred to, but just to dwell on what the evidence was recorded in the judgment. It's paragraph 263, page 378. You have at the bottom of the page the witness evidence from Apple's principal factual witness, Miss Heather Muse. And may I perhaps just invite the court, I won't read it all out in court. If you read that paragraph extracted by the judge for yourself, to see the way that she describes what occurred.
Yeah, we'll do that.
Now, there
Sorry,
was...
do you want, should we do that?
I'm sorry, ma'am.
You don't want us to do that now? Or
Oh no, I'm sorry, it's a short paragraph.
Yes.
If you perhaps just look at that now.
Yes.
No doubt you will come in due course to what the judge says at 265.
Yes, my lord. Now, essentially, she describes first the policy, which she gives the name in the second line, no license, no chip. Then she describes the particular way that it affected the patent licensing agreement with Apple just below that. Mr. Speck referred to the fact that we hadn't referred to the cross-examination of the witness on this. If I may say so, there was no cross-examination of Apple's witness on these points that you've just read in her evidence, even though the witness referred Mr. Speck to them when he was asking her about the Qualcomm license. One point that we made, our point here was, and it remains, that in the light of this evidence, the judge was entitled, when you couple this with what he saw were anomalous rates charged by Qualcomm, again we will be coming to this too, the judge was entitled, and we say entirely right, not to treat this as a safe or reliable comparable. In our submission, he didn't need to reach specific findings of fact about it beyond the ones that he did in the judgment, which was to observe that this demonstrated the exercise of market power. We can come back to it, but that's on page 90 of the judgment, where he refers to this being an exercise of market power on the evidence that he had seen. We did not ask the court for a finding that Qualcomm had behaved unlawfully, whether under the law of the United Kingdom, where there's now a pending case concerning the rate setting to Apple in particular, or Korea, which was mentioned during my friend's address, or anywhere else across the world where the same concerns have been raised by the public authorities and by implementers. That was our essential case, and we weren't asking for any evaluative findings.
So the submission is no smoke without fire?
The submission is that there's a reason here for the judge in their evaluative judgment not to rely on this when they couple what they see in the rates with what the witness has told them about the way in which that has come about. So it's essentially saying that this may well be a case, and it tells the judge that he should underline in red the number that he sees and is entitled to treat it with due caution.
Can I just be clear on one thing? Is the reference to unlawfulness a red herring? I mean, unlawfulness could arise, I suppose, from anti-competitive behaviour in competition law terms.
Yes.
But that's not what we're concerned with, is it? Or not what the judge was necessarily concerned with. He was concerned with whether this could be treated as a market rate to be taken into account.
My lord, yes, and that is our point, that the judge didn't need to look specifically at this behaviour, make findings of fact about certainly what it entailed in terms of whether this was unlawful or lawful.
But
he says,
why lawful or unlawful? I'm not quite sure why that's the question.
It shouldn't be, and it is not. Absolutely, my lord. I disclaim it as any part of what was argued. I'm simply making the observation that where we were referring to the way in which this is being looked at, the practice across the world, it is something which...
You can't have it both ways. You accept that it's irrelevant, but on the other hand, you're still trying to rely upon the fact that there's investigations, even those investigations have not led to any adverse findings, and even if they did lead to adverse findings, you'd have a Hollington and Hewthorne problem.
Well, my lord, let me take that in stages. I understand that where your lordship's coming from. First, there were adverse findings. So in Korea, the Supreme Court has upheld this as being a practice of concern. So that is the case. Second, though, you're absolutely right. We're not referring to this on the basis that the findings of anti-competitive behaviour in those judgments, or the particular way in which it is said to have manifested, are things that this court should accept. And I do see your lordship's point on Hollington and Hewthorne, but we're merely referring to the foreign judgments and the foreign activity in a different way, because it's unexceptionable under the Hollington and Hewthorne rule that you can refer, as your lordship knows, to other judgments, at least for the evidential record, to see what is being argued and what the facts on the evidential record are. So, for example, in this very appeal, my friend was referring to one of the US judgments concerning Qualcomm and drawing attention to the fact there that he wanted this court to take into account. And what we're saying here is not so very different from that.
I mean, just to be clear, the judge, if he was concerned at all with whether there was unlawful behaviour, that certainly wasn't the only question, because short of unlawful behaviour, potentially the judge was entitled to have regard to behaviour that would make this an unrepresentative deal. But then there's a further question. If that was an issue, did he need to make findings about it?
Yes. So, my lord, we agree with the way you've put it. The relevant question for the Frand Court is whether this comparable, essentially, is representative, whether it's reliable. And we say that he is entitled to do what he did, and on page 490, which we can perhaps look at either now or in due course, what the judge does is he says, coupled with the rates that I see here, or in fact he says, the way he puts it is in the light, let's open it up. What he says is, in the light of the rates that I see here, which he comments on the previous page, I see this as essentially involving an exercise of market power. Let me show you the way that he does reason it. So page 490, Roman 6, bottom of the page. First thing that the judge does there is he makes some comments about the tremendous effect of including this single license in his figures. He comments what a high fraction the royalties payable to this single undertaking among all of the others accounts for the total. And there's a number of very large players there. And you'll see in blue on the fourth line what the figure is. And his comment in the third line up from the bottom on 6 is this one license makes an enormous difference and supports Apple's contention that Qualcomm ought to be excluded as unrepresentative because of Qualcomm's market power as against Apple. So he is saying that on the material he's seen, this supports the contention that was advanced before him, that there was an
He doesn't
exercise.
exclude it.
I'm sorry, my lord.
He doesn't exclude it.
You mean he doesn't exclude the comparable?
Yes.
Well, yes. As I say, I shall turn to this, but let's turn over and just be clear about what he does do. If you then go over the page, at letter B, you'll see the colourful phrase that the judge uses about what has happened here is a colloquialism in the first line. But what he says he's doing is not including it almost as a comparable in its own right. He is altering it, as my friend pointed out, for a particular reason, so that there is a counterweight to something else.
I have to say, you'll obviously come to this. The way in which he's altered it is hard to justify.
My lord, let's see first of all what he does, yes. and then may I give you an initial comment on that, because yes. As you've raised it, I should deal with it.
Well, honestly, I've taken this entirely out of your course, so come to us in due course.
Well, all right, but to complete this as I'm here, what he does in B is that he refers to this being a case again where, well, I won't use the judge's expression, but essentially it's a counterparty, as you see from the second line, with relatively great market power. And then you see at C again, 3 lines up from the bottom, a figure that sufficiently represents a case of mismatch in market power to Apple's disadvantage. So may I briefly then, because your lordship's raised it, I'll make 2 points and then I'll move on. The first is that your lordship's right. He's not, he's not here referring to the Qualcomm comparable being taken into account as a freestanding matter. He's saying, I see here that there is an exercise of great market power. He says at B above that, I do have it's not so much a concern, but I want to be precautionary in case Apple may have exerted their own market pressure on smaller counterparties, something which he doesn't, by the way, find, but it's something you'll see later. He says, I'm on guard to the risk of. And then he adopts this technique for giving some weight in order to address that risk. So in a sense, your lordship's absolutely right, and so is my Lord Justice Arnold. He's not really taking the Qualcomm comparable into account as a freestanding matter in its own right at all. What he's doing is finding a way of addressing something else he sees as a risk, as a precaution. Your lordship then says, well, your lordship then says that this is a very odd way of going about it. We say that he could, partly in agreement with that the judge could have done it differently. He could have just said, if I exclude this and I bump up the average figure by 10%, that will do it on a broad brush basis. And that would have been a broad exercise of his evaluative judgment. Your lordship makes the observation, what he's done here looks like it's some kind of mathematical exercise.
I mean, Qualcomm has become 1/19th of an average, I think.
Yes, but
I may have my denominator wrong, but it's at any rate it's become one element in a much larger.
No, your lordship's absolutely right. But the reason why it has an effect, it's still after his adjustment bumps up the average figure by about 12%. I think I'm allowed to say. I'm not allowed to say. This is not going to be an easy appeal.
No.
But the reason why it bumps up the average figure is because of the point that he's made at 6 on the previous page, in the 4th line, that the royalties payable to that one of the 19 is an absolute giant among the others. And so even if you take an average, it has a big effect in bumping it up.
Can I ask one further thing? The judge is proceeding on the basis, as you say, that Qualcomm had disproportionate market power, seemingly. To arrive at that conclusion, he presumably had to accept the evidence given in paragraph 263, referred to in paragraph 263.
No, my lord, logically, no. What he says on the on page 490 is that this supports Apple's contention, which was the evidence that was given. But what he is actually doing is he's simply referring here to the anomaly. He's looking at the numbers and he's commenting above at the extreme difference that he sees in the numbers.
Well, he says Apple has been taken to the cleaners.
He does.
By a counterparty with more market power. Now, how do you make that finding unless you're accepting the evidence referred to in paragraph 263?
Well, my lord, he may have. I'm largely in agreement with that point. But strictly, if one sees that you have a range of other counterparties, which include what the judge called elsewhere the big beasts, so you have Ericsson, Huawei, Nokia, and the like. And by this point in the reasoning, the judge has made his own decision that there's been fair and robust negotiation with them. So he's come to the conclusion that those are representative. At this point, he now says, well, I see this one standing out like a sore thumb. And so it's possible to infer from that disparity that there has been the exercise of market power.
I mean, breaking that down, maybe a judge, at least with the benefit of expert evidence, which of course he doesn't seem to have had, could say, well, look, it's appropriate to disregard an outlier like this. But in terms of his justifying it by the exercise of market power, how does that fit with his approach to Apple and Hold Up? I mean, he's saying that's all fine, and that doesn't distort the Apple comparables. So why does it make Qualcomm irrelevant?
When you say hold up there, did you mean hold out?
I did, I'm sorry, yes.
Because, and it will need to be a separate topic in its own right. When I come to address what my friend said about that, the judge's conclusion, and we will look at it, is that the negotiations between Apple and the other counterparties, and he runs through that, Mr. Speck showed you quite a lot of that reasoning, did not involve the exercise of hold out.
But the judge says,
or
in
at
terms,
least, I'm sorry.
He says in terms somewhere that nearly all such things are legitimate. I can't remember where that is.
Milo, do you mean the when you say all such things? Do you mean the sort of the patent by patent point, or do you mean something else?
I think I have in mind, say paragraph 271.
Yes. Paragraph 271.
Sorry, 371.
Yes. Ah, yes. Yes.
So he's saying this is all fine. But yet when he comes to Qualcomm, it's not.
Yes, so my lord, I'm glad that you've raised that, because to unpick it, and again it's to anticipate the argument, the judge does draw a distinction in this judgment between what he calls illegitimate and legitimate, hold up and hold out. When he is referring to the legitimate hold up on the part of a SEP owner, he's saying, well, you must be able to threaten an injunction to vindicate your rights in these cases. And he says, well, that's a form of hold up, that's legitimate. When he turns to the implementers, and we'll get the references, he says, well, when you're bargaining, you mustn't just be in the position where you need to capitulate. if someone is putting forward a rate that is too high, or arguments that you think are wrong, or if there is material they put forward that you need to consider, and that is involved in the process, if there isn't excessive delay following from a strategy of delay, then that is legitimate. Now, it is unfortunate that this judge is using these terms, as Mr. Speck says, legitimate hold up is prima facie legitimate, is not a happy way to phrase it. But my submission here, and I'll make this as one of my headline points in a moment when I get on to the headline points, is that this is a judgment where it's a long judgment. I'm not going to shrink from the proposition that in a number of respects it is not happily expressed, and that there are internal difficulties and tensions which do need to be reconciled, and that sometimes the choice of phraseology, as with this, can be the basis of taking one down a rabbit hole. Because essentially you will see that when he talks about legitimate holdout, subject to the point about behaviour that was acceptable prior to the Supreme Court and Unwired Planet, which I'll come to separately, he largely has in mind that in this case, in the court below, the way that Optis ran the case was essentially to cry holdout at almost anything that moved. And the judge makes the comment that essentially legitimate bargaining and the ability to consider material that's been given and to come back at it, that is, and he calls it, and he shouldn't have done, but he calls it a species of holdout. He calls it legitimate holdout. But he has well in mind, as I will come to, the mischief of proper holdout as it is used as a term of art. So, my lord, then returning to Qualcomm, the holdout, as it were, in relation to the other counterparties is not illegitimate holdout in the judge's terminology. It was fair and robust negotiation, and he thought the comparables were reliable. Here what he sees is that one counterparty has achieved a massive win in using...
He doesn't say Qualcomm guilty of holdout.
No, and to be precise, it wouldn't be hold up in the conventional sense of going around getting injunctions. It's using your power in a separate sphere, which is the supply of the...
Sorry, why is that not a manifestation of hold up?
Well, it may be that I am interpreting the word hold up in too narrow a frame, but I'm thinking of hold up as essentially taking out...
Getting more out of the portfolio than it's worth.
Well, my lord, if that is it, then I entirely agree. The mechanism here is different, because if you're the supplier, I'll just put this very simply then. For traditional hold-up, we have in mind, you go and you get injunctions in other jurisdictions and so forth, and you stop the implementer from selling in those jurisdictions. Here you have somebody who is a key supplier of a physical input you need for your handsets. And if they say, I'm not supplying you, it's like a global injunction. You cannot make or sell the handsets anywhere. So your lordship's right, it has a similar augmented effect. And in that sense, I can use the term hold up. It's just that it isn't necessarily the way it has been used in other contexts. Now, trying to maximise all the time I can,
yes,
given the pressures. I see we're coming up for lunch, but if I may just make a little bit more progress. I said I was going to go on, so here I'm really just fleshing things out before I turn to these famous headline points. In the second group of Optis's grounds of appeal, that's the valuation, grounds 5 to 9, and the premise is we Optis accept the legitimacy of what the judge did, his basic approach to valuation, but we pick out what we say are a number of errors of implementation that amount to appealable errors, inconsistencies, gaps in logic and the like. Optis is arguing that this court can and should correct these on appeal, That's led to the various iterations of the spreadsheets and the tables that we've been discussing. And we say, and we will aim to show you, that the approach taken to arriving at those figures in the spreadsheets is not just based on adjustments to the judge's approach, which this court well understands. It didn't need to be such a radical adjustment to the judge's approach to take account of the errors that they say existed. But what they have chosen to do via these spreadsheets and tables is return to a method which is based on the very same unpackings of individual licenses and the same methodology that was rejected by the judge. And I will come to it, we say, on a reasonable basis in favour of the approach that he took. So that is just an initial comment about an issue that will arise for those grounds. So far as anchoring is concerned, I shan't make any comments now. I will begin then with the headline observations, and perhaps it's convenient for me to take those after the short adjournment.
2 o'clock.